Some new insight on the Karen Read case. In this episode, a special guest, attorney Mark Bederow.
There's been new updates in the Karen Read case, and we have a special guest to help us look at them. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have the special player of having attorney Mark Bederow with us. Hello, how are you doing today?
Hi, how you guys doing? Glad to be here.
Yeah, thanks for being with us. I'm sure most of our viewers know who you are, even though we haven't been privileged enough to have you on the show before. But just for those who don't know, you were the first person to publicly reveal that Norfolk County's grand jury refused to indict Karen Read and your client Aidan Kearney in their alleged conspiracy to intimidate witnesses. The grand jury returned a no bill. And you also notably unveiled that despite Mr. Kearney's phone being seized way back in October of 2023 and the Celebrite extraction being done in October of 2023 by Mr. Tully, Detective Lieutenant Tully, the Commonwealth continued, at least in a recent letter that you wrote to the court, continued to maintain that the phones have not been searched. And might I add that I do understand that for a lengthy period of time, you were a prosecutor with the Manhattan District Attorney's Office, and now you're a defense attorney and have been for many years. Do I have that right?
You have it right. Yes.
Okay. I guess the first question is, I know that you watched, as did we, the hearing in Norfolk County Superior Court, the first time that Hank Brennan, the special prosecutor, appeared. And I'd just like to ask you generally first, what were your impressions of that?
I mean, the first thought I have is kind of before the court appearance, which is, why is he there? That question has yet to still be answered. There's no conflict here because, as you saw, the Norfolk ADA who tried the first case is sitting right there. And it's bizarre, odd, peculiar, something I've never seen, where a special assistant district attorney is brought in essentially as a ringer at taxpayer expense to help out a decent sized prosecutor's office. And so to me, the first thought is, why is he there? I don't think that question has been asked or answered. And the only thing that comes to mind is that either nobody in that office is willing to do it, or there's just nobody capable of doing it. And neither one of those choices seems to be a good one if you believe in the credibility of the DA's office. As far as the appearance itself, it was a little surprising. I mean, it was a very disjointed rollout, I think, to be kind.
Can I just stop you for a second? You pointed out that no one has really asked the district attorney himself why they're doing this. As you know, Vanity Fair several weeks ago had an article in which they said that none of the top prosecutors would try the case, that the top prosecutors refused to try the case. Well, way back on October 31st, I not only called the district attorney's office and was shuttled off to the press office, in which I actually spoke to a person, and they said, no comment, no comment, no comment. So on October 31st, I wrote a letter to District Attorney Morrissey on my letterhead, and I faxed it to them, and I just simply asked them, I gave them the quote that none of their top prosecutors would try the case a second time. And I said, could you please simply confirm or deny? And my phone hasn't been ringing, so I know it's them.
Well,
so
the no comment ordinarily is the right thing for a prosecutor to say to inquiries. However, in this situation, it's not, because what they're doing here is taking your money, taxpayer money, to hire an outsider at public expense when they have 40 to 50 attorneys whose job it is to do this, and they owe the public an explanation. Simply, why is that? I mean, I think good government principles demand an answer. Why are our tax dollars being used to fund private people to do what public dollars already pay for? So
notably, the district attorney just very recently, just in the last month, hired a very new press spokesman who used to be with one of the newspapers in this area. He retired from the newspaper to become the press secretary. What is he doing? As you noted, a lot of money is being spent in the DA's office. what is he doing? If not, I mean, no, I don't expect a personal answer, but how hard would it be for him to scribble out a 1-paragraph thing, deny or true, and post it on their website where they post press releases? How hard would it be for them to do that?
I agree. And I also think there's a failure in media because when they brought Hank Brennan on, which is newsworthy. I mean, the guy is, by all accounts, a very credentialed, accomplished attorney. Nevertheless, in private practice for however many years, and all they focused on was Whitey Bulger, which is interesting, but that's kind of a sideshow footnote. It gives it a little color, if you will. But the question that the media ought to be asking is, why are you doing this? I mean, this makes no sense. There's no conflict here. Adam Lally was sitting there twiddling his pen yesterday or the day before the whole time, staring at his notebook. So they're still on the case. None of that makes any sense. That's the responsibility of the media to do that. But as far as the proceeding itself, I thought it was a very disjointed rollout. One would have expected a more fluid, confident, there's a new sheriff in town and we're going to be ready to go and here's what we're going to do. And instead what you saw was, inexplicably, I think, the failure to serve parties on third-party subpoena motions. I mean, that's pretty basic stuff, I think. Yeah. I mean, I know Massachusetts, which I'm learning about their procedures every day. I'm not admitted formally in the state, just for one matter. But, they are unique, certainly different from New York, where in order to get a third-party subpoena, you need to have this hearing every single time with this Rule 17 stuff, which is very different. But nevertheless, anyone who's been doing this in Massachusetts understands that, and certainly understands you have to serve third parties. And it didn't happen yesterday. And that's clumsy to me. And it's a very high-profile proceeding. It's televised or broadcast, whatever the word is. You have lawyers flying in from California to be there, to have to come back multiple times over the next few weeks to do what should have been done. So I thought that looked clunky. I think the issue over the new prosecution expert, so-called expert, over the telematics, the infotainment stuff that they want to pull off the Lexus, so far has been a disaster when you have a technical expert who can't decipher the difference between bits and bytes. Listen, people like you and me can get away with that because we're not technical experts, but we hire experts specifically to make us look good and do it right.
And you spend a lot of money on an expert in a case like this, a lot of money, over and above what Mr. Brennan is being paid. They spend money on this. I want to back up a little bit and break it down. When you say it looked like a strange occurrence, the way this was rolled out. Mr. Brennan said, as you know, that he was still in the process of evaluating the case. And I don't know. I know a lot of YouTubers that have watched the whole thing. And I know as an attorney, that's not good enough. You want to read the transcript. But wouldn't that be the first thing you do, is read the transcript?
Yes. I mean, I was pretty surprised that as part of the argument for adjourning the matter a couple of months to further prepare for trial, there was a pretty shocking, candid admission, which was a stated lack of complete familiarity with the first trial, whether that means reading the transcripts, which can be boring, but that's what we do on a daily basis, or perhaps an even more entertaining way, as you said, just turn on YouTube. There's 8,000 channels that have gavel-to-gavel coverage of this. If you are planning to retry a case of this magnitude, and you have a million things to prepare, that's understandable. But I agree with you. Literally, task number one would be, what the hell happened at the first trial? What am I dealing with? And yes, and as far as we know, he signed on several months ago at this point, 2 or 3 months, whatever it is. I wouldn't expect them to be literally ready to try the case yesterday from when he joined, given what it is. But you would expect to have, I think, to be fair and candid to the whole process, an understanding of who the witnesses testify. I mean, if they're talking about, we're going to streamline the case, we're going to get rid of this person, keep that, that's suggesting you're familiar with the trial. But the representation that was made yesterday was, I'm not fully familiar with the trial. I found that surprising. But listen, he's a professional. He'll be ready whenever ready is. But it just struck me as clunky in light of the media buildup that this was going to be the savior of all saviors, and she's screwed because the DA made a decision to bring in a more skilled and accomplished lawyer, which I'm sure they have. But, not serving parties, having experts who are literally discrediting themselves right out of the gate by not knowing basic technical information, or alternatively not reading carefully and making a mistake, which doesn't do them much better either if you're supposed to be an expert. I just thought it was a very clunky, meaningless hearing, and all it did was lead the judge to say, you're all going to have to come back several times.
Yeah.
And there are, again, obviously the judge is not impressed that 67% of the lawyers on the case come from California. That's obvious with the topic about red-eye flights and
Oh my gosh.
all of that sort of thing. But I mean, that is, some would say outrageous to have to come back to redo what should have been done yesterday at great cost and expense, and, flying out an expert who already testified at the first trial to have a Daubert hearing when she has already cleared the threshold. That's bizarre. And let me just, because one of the things I thought was disturbing about that yesterday was the prosecutor said, I have issues with her, and we want a hearing, which is fine. That's your position. What the judge did was just say, well, then bring her out for a hearing, instead of saying, well, wait a minute, I've heard this before. I allowed her testimony. I've already gone through this. Give me an offer of proof about what's going to be different, so I can at least decide whether this is appropriate. And sure enough, boom, she just says, bring your witness out and come back from California. And, that didn't sit right with me.
Yeah, no, it didn't make any sense to me either, because I remember it was towards the end of the trial that they actually had a recess in the trial, and they did the Daubert hearing for the emergency room physician who testified that they were animal bites on John O'Keefe's arm. But why aren't they talking about a Daubert hearing for the prosecution's new expert who's going to be going through the telematics in the car? That didn't make any sense to me.
I don't understand that either. I mean, and the difference here is the expert who already testified. I mean, you know the drill with her. She worked in an emergency room for years. It's the suburban noise in the background.
We know it well.
Yeah. She evaluated numerous animal bite and scratch injuries. And if my memory serves correct, she literally wrote a paper on evaluating animal bites and dog bites. So she obviously is credentialed. But even before you heard anything about the telematics testing, you already have the guy who screwed up the bites and bits. And if anybody seems ripe for questioning to explain how the hell that happened, it would seem to be that guy. I mean, this case is so bizarre. I mean, when have you ever seen a situation where the defense says, we don't object to retesting if it can be done. In fact, we want that, which I think is interesting, and it's not getting enough attention. But we just don't trust the prosecution expert to do it. And there is a risk that by testing it, you could destroy the data, which the defense is making very clear they believe is going to help them. So we want to be able to kind of have a guardrail in that process by having our expert be able to call a timeout and go to the court and say, before you touch this, let us get judicial intervention or whatnot. And, that's, there's no way the judge was going to grant that. But it would seem to me that expert's, ability and testimony should be subject to a Daubert screening.
Absolutely. That was my question. Yeah. You stole my next question. And I think you mostly answered, but my next question to you was going to be this whole idea of, okay, the Commonwealth's expert is going to be allowed to go in and do whatever he does with the chips and the boards and all that. And the defense, they only have 5 days, but they can name an expert to observe. Okay, what if they observe something that they don't like? What do they do? Say, hey, knock it off. And the other guy says, no, I won't. Do they get on the telephones and call their attorneys? Do the attorneys work it out? Or are they going to be filing interminable motions like in the old days during depositions? Are they going to bring the attorneys in? I mean, that seemed to be an open question to me that made no sense.
It didn't. But one believes that based upon the argument yesterday and the other rulings of the case, that the answer is just going to be, you have 5 days to have your expert witness attend. And I think they're going to be deduced to doing nothing other than taking notes, observations, like you compared it to a deposition. They can object to form, make a record, and then deal with it either in a motion or cross-examination, or, their own defense expert testifying that this is what happened and that's why it's not reliable. But once again, we're burying the lead here, which is, what if there is information that is entirely exculpatory that would favor the defense, and this witness inadvertently screws it up and destroys it, not on purpose. I don't.
It happens.
It does happen. And
I do mostly civil law, but I've seen that happen in products liability cases in which something inadvertently, as you say, accidentally, happens, and it does happen.
It does. And I think both sides recognize scientifically, and they even discussed it, that there is risk in doing this chip off or whatever they call it, that you may just in fact destroy whatever data is there. That is a serious possibility.
Now, let me ask you this. Judge Kearney did not act on the motion to continue the trial date from January 27th to April 1st. My impression was she just wants to keep the pressure on the attorneys. She wants to keep pushing them around. But my guess is that, she said she wasn't going to approve it at this time. My guess is that after she has some fun with the attorneys, she will allow it. I don't know. What's your take on that?
I think that may be accurate. And I think she, again, there's a new lawyer in the courtroom, who's, let's be honest, a lot more alpha than the prior prosecutor. You definitely have alphas on the defense, and I think it may very well been her way of saying, it's my sandbox, right? I decide,
right? And
ultimately, we'll see where that goes. But also, she kind of ignored the other issue here, which is that the SJC may make that meaningless by however long they take to determine the issue that's presently before them, or in the scheduling doomsday scenario, suppose they send it back, the double jeopardy issue for a hearing. I mean, suppose, and then the judge has to rule again, and then they're going to appeal again, and now you're talking months, and there's no way that case would go in January if that's the ruling. I mean, obviously, if the ruling is you're out, then you go from there. By
the way, I did just check before we came on. I went on the SJC website, and nothing had been announced as of the time we started this. I'm not a conspiracy theorist, but my theory is they're going to release that the day before Thanksgiving. I don't know.
Or a Friday at 5:00.
Right.
So now, come back in about a couple of hours.
Yeah.
Do you think that in a trial of this length, they'll be able to organize all the evidence? They were talking in this hearing about Bates stamping everything, which would be great. But why didn't they do that the first time? I couldn't believe it.
Well, it's funny you say that, because, that is the ultimate unintended but maybe intended emasculation of Lally. Who's sitting right there. And as the new prosecutor, who, again, is an experienced, accomplished lawyer, recognizes that in any case in which you have thousands of pages of discovery, you have rolling disclosures, meaning they come out piecemeal. Most experienced lawyers, including from large prosecutors' offices, would go out of their way to Bates, and yes, Bates with an S, not bait like they keep writing in their filings, which is a little odd, but whatever.
Big stamp.
Yeah. Would literally mark the evidence and make a cover sheet saying what they've given, so that there's no issues and concerns. So listening to him say that, and listening to him say that I'm going to go above and beyond and make sure that I'm going to disclose everything I'm obligated to disclose, which sounds lovely, but at the same time you say, well, yeah, that's what the law requires you to do. Why didn't they do that the last time? So, I think that was good to hear from Brennan.
Good job doing your job. Like,
Sure.
congratulations.
But on the other hand, the defense needs to get whatever they're entitled to get, and they need to get it in proper time. And so I applaud him, if that's the right word, like you said, for doing his job. But the reality is they didn't do it in the first trial. They were piecemeal, disclosing evidence in the middle of trial, including this now famous inverted video.
I was just going to ask you about that. I mean, I couldn't, my jaw dropped when it came out that it was backwards, but did I hear correctly that the defense claims that they didn't even have that evidence before the trial? If that's true, isn't that grounds for a mistrial?
That is absolutely. And again, we don't know about these sidebars that are sealed and that are going to be unsealed, or excuse me, I'm in Massachusetts, impounded.
Right.
Impounded. Maybe it's at the bench, but what would usually happen, and I'm not sure if it happened here or not, because she didn't want anything in open court on the record, public record. I mean, that is beyond flagrant in terms of a outrageous discovery violation. I mean, a video from the sallyport showing the alleged instrumentality of death, the vehicle, as the police got it, even before you get to that, to give that over in the middle of trial and just nonchalantly say, yeah, we just got it from the Canton police, as if to say, who cares? Then you find out not only is it inverted, but if they only got the inverted video, if that's even true, then Lally had an ethical obligation clearly to indicate, if he's even going to try to offer this garbage evidence, to tell the court and defense through the witness, have, as part of the direct examination, have the witness, instead of perjuring himself, say that, oh, by the way, it's accurate up to the degree that it's flipped, inverted, whatever the word is. They didn't do that until they got caught with their pants down on cross. Yeah. And if that's not bad enough, it's not just a minor error, because what happens is, by inverting it, the wrong taillight is missing. And clearly, one would assume that the prosecution would want the right rear taillight front and center, blinking Christmas lights saying it's broken. And oh, by the way, the guy standing behind it off camera just happens to be a guy named Michael Proctor, who is alleged to have done all kinds of corrupt things. And that's all taken off camera. That should have been a mistrial then and there.
Oh, I agree 100% because there were actually questions on cross-examination. Who are those guys in the back? Oh, we don't even know. Couldn't it have been Michael Proctor? Oh, maybe it could have been him. And they're in the back. They're away from the headlight the taillight that they're showing as the right taillight. No, it was the left one. And the guys lurking in the back, in fact, are lurking right around the taillight that some people say was intentionally broken and the pieces spread. So
it's even worse than that, though, because the testimony on direct from Sergeant Buchanan was, that's me, that's Proctor, and no hesitation. Mm-hmm. There we are. And by the time word got out that this was a, fugazi video, for lack of a better term, and there was a problem here on cross-examination, he got a little amnesia, a little less certain, and so, well, maybe it's me, maybe it's not me. This is
who knows?
Real sketchy stuff. And for this to happen in, something akin to the trial of the century, or certainly of the magnitude that this is, honestly, it just makes you wonder what happens in the cases that aren't on the public radar in that county, when other people maybe have less means than Karen Reed, less accomplished lawyers than Karen Reed, are being tried for crimes as serious. I mean, if they're willing to do that in a case where everyone's watching, it really makes you wonder, are they willing to do that in cases where there isn't that kind of sunlight?
Yeah, I've been practicing law in Massachusetts for over 30 years, but I've been watching things for 50 years. And with the exception of the Whitey trial, this is the biggest state case that I can remember. There have been some big ones, but this is the biggest state case that I can remember in all of those years of watching things. And so a question I have for you is, if they come in and Hank Brennan gets all these new experts and new data from the car and all this stuff is new, and they try to present a new and improved, cleaned up version of the trial, cannot the defense attorneys, who are also extremely skilled now on impeachment, bring in all the old evidence that would impeach all the new stuff?
Yeah, and there's many clever ways you can do that. And certainly, the most obvious way would be in attacking the opinion of the new expert. Clearly, you're going to want to know what materials did you review, analyze, and do whatever to reach your conclusion. I mean, it's a common sense thing to try to get an expert to justify what led to the basis of their conclusion. And, certainly whoever this new expert is, Mr. Burgess or whoever, the accident reconstruction guy, whoever he is that they're going to use, you can be sure they're going to hear a lot about the name of, Trooper Paul and
Joseph Paul.
Right. Pirouetting and the crime scene revealing itself and the arm injury and, bouncing off the ground and, 30 feet away and all that kind of stuff. And presumably you'd expect the new expert to just kind of roll his eyes and say, yeah, that's not really what happened. And then,
Mr. Burgess, isn't it true that in the first trial of this case, Trooper Joseph Paul, who said he was an accident reconstructionist, didn't say it was a rear end accident? Isn't it true that he said it was a side swipe accident? And didn't he also say that it was only consistent with? He never said it was beyond a reasonable doubt, did he?
And the other problem they're going to have, again, because they can use Trooper Paul, he was in a better position to evaluate than the new one is. So even though I think anyone, who's half sane would tell you that Trooper Paul was one of the worst so-called expert witnesses. I mean, that was just cringe inducing to watch. And the man was not qualified. I mean, I think that's fair to say. And even the Commonwealth recognizes that. But he was in a position better suited to reach an opinion than the new person. I mean, he's boots on the ground in late January 2022 when there's still snow on the ground on Fairview Road. He's able to do things in real time. He saw the car, at that time. He did things at that time, whereas whoever they're bringing in now is just relying upon a completely cold record and a, obviously flawed opinion from the previous expert, and is being paid, a sum of money, unlike the ARCA witnesses. So therein lies another problem. The ARCA witnesses, who the defense will have a chance to prep this time, I imagine. I don't think the feds are going to have that protective order about them. Cat's out of the bag. They're not paid for. And I'm sure they'll make abundantly clear that by not paid for, that means Karen Reed's insurance company, or anyone else, that they are literally neutral people that were brought in by, another agency, or however they're going to phrase it, as opposed to, the Commonwealth. And the first time they try a state trooper, it doesn't work. Now they're wasting more tax money to pay for an opinion by someone else. And then the real bottom line problem they're going to have with this, though, is, what expert are they going to bring in who is going to literally discredit these ARCA guys? And with the burden of proof for the prosecution, they need to win that battle overwhelmingly, right? They can't cancel each other out. That doesn't get them anywhere with reasonable doubt.
No, and the other question that really bothers me is that the facts are the facts. So they have this new guy, Burgess, and he goes in and he gets all of this stuff. Well, but wait, the accident facts are the non-accident facts are the non-accident facts. The ARCA guys said there was no rear-end collision that hit Mr. O'Keefe, that the injuries on the arm were not from a car, they were from a dog bite. So the facts are the facts. Even if a new witness comes in and looks at the same stuff that Joseph Paul did, as you said, Joseph Paul was in the best position to observe the facts. So how can a new expert come in and contradict him? It makes no sense. The other question I have for you is, how can I'm not going to put you in his seat and say, well, if you were Hank Brennan, would you?
I wouldn't touch this with a 20-foot pole. I would put away. No, look, give him credit for embracing the challenge, but I
do. I know Mr. Brennan.
Away from this.
I know Mr. Brennan. He's a friend of a friend. I've met him. I've sat in an office with him. I'm sure many, 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 many people in the greater Boston area can say the same thing. He's an excellent attorney. He's a sharp man. He's very focused. He's very organized. And anybody that goes up against him has got a long day ahead of him. But what I was going to ask you is, how can he in good faith show another video of this Lexus in the sallyport? And how is he going to explain that it was shown backwards the first time? There was an image that was backwards because some astute attorney said, wait a minute, the wording on another car is backwards, but the timestamp is correct. So
They're
How can you, with
never-
a straight face, put that evidence on a second time?
and they can't, because there is video of Yuri Buchanan under oath ignoring that issue and very calmly, cool, collectedly saying it's a fair and accurate portrayal of what's going on. And there's me, there's Proctor, who the prosecution probably won't even call. And then he's going to get hit with all this. But these are the issues that make me wonder how an accomplished lawyer and a defense lawyer, and of course, once you go to that side, your brain reshifts and you look for things that don't make sense. What I'm struggling with is, to your point, how can he, in good conscience and with his own credibility, say, well, that's okay. Then you look at the ARCA stuff, right? I mean, those are, and say, well, how am I going to get past that? You deal with the Proctor stuff, and it's not just the text messages. He says he towed the car at 5:30, but there's the video at 4:15. You had the car, and oh, by the way, the red taillight is lit up. And oh, by the way, there is time to tow that car and for, a taillight to magically appear. Doesn't mean he did it or not, but their whole argument was it wasn't possible initially because he towed the car at 5:30. How are they going to, with a straight face, say we brought in this exclusive, what do they call them, a CERT team, right? This is like the ace search guys to look for what was a car accident, and they find a few pieces of taillight and they say, pack it in, guys, it's bud time, we're done. And nobody says, well, wait a minute, it's nighttime. We know the car is missing, I'm making this number up, but 80% of the taillight, we just found about, 2% of it. And nobody says, at a minimum with a straight face, maybe what we do is we come back in the morning when it's, that thing called daylight. We bring an extra 10 guys with more shovels and do this again until we find all of it. And
well, what about the leaf
I was
blowers?
gonna say, you
What
don't
about the
wanna
neighbors'
blow the
leaf
evidence
blowers?
away.
Why couldn't they keep going with the leaf blower?
terrible, but to stay on the taillight even for a minute. And then you're going to have testimony that the chief of police, magically, with his big Coke bottle glasses, somehow saw a piece of taillight and, oh, there it is. And right then and there, they didn't call for a search team. And then Buchanan and Proctor are going to say over the course of 2 weeks, more evidence just revealed itself, whatever the words they used. It's hard for me to believe how an experienced lawyer who, embarrassing or not, is on record, probably related to an interview with the Whitey Bulger case, saying, if you have a case where there's bad cops and they're not credible, then you have no case. Well, hello, that's the Karen Reed case. I mean, you can substitute each case for that. So I don't know where they're going. And I mean, again, from a defense attorney standpoint, like, to go to the leaf blowers and the solo cups and all of that, even before that, the testimony and the evidence will be, that testimony was, as evidence will be at a second trial, that they never secured a crime scene. I mean, they literally left it abandoned and open to anyone for a dead police officer on a police officer's lawn, which is disgraceful. But once they lost control of the crime scene, they lost control of the case.
Yeah, I think even a kid who watches CSI knows that the first thing the cops do is they put that tape up and they post police officers at every corner and keep people away. That's elementary, and even a TV casual viewer knows that.
Anyone who has experience as a prosecutor, defense attorney, especially in a big city where unfortunately you have more police deaths, if you will, everybody knows that when a man down or officer down, the reaction of the local police, the state police, the district attorney, if it turns out to be the U.S. attorney, whoever's handling it, it is all hands on deck to know. In other words, when you saw the funeral of John O'Keefe, you saw the proper reaction for officer down. But when there was a dead body who just happened to be a police officer on the lawn of another police officer, you saw crickets, an abandoned crime scene, and we'll just go down and seize the vehicle.
When I was in law school, I went to Suffolk. I lived for a while in what they call the South End of Boston. Wasn't a great place then. They called it up and coming. But one of my many experiences making me move from the South End of Boston was one night I heard a shooting, and I looked out the window, and a Boston police officer had been shot. I lost count at 26 police cruisers that were there within a minute.
30
They came out of nowhere. I'd never seen more flashing blue lights in my entire life. Now, sure, that's Boston, but Canton is a town that's metropolitan suburbs. It's not that far from Boston. And notably, Interstate 93, one of the busiest roads in the Northeast, is right there. So to your point,
Hey, listen, 93 and 95. I mean, it's literally the intersection. Is Canton.
Yeah. So I want to ask you a crazy question. And that is, Hank Brennan in this hearing, the first hearing he went to, had his head to the camera. And I'm not a body mechanics fan. I'm not a fan of people that say, well, this person sat there and the other person sat there, so from that we can read this. But didn't that strike you a little bit odd that, you know, he went right up almost to the bench and spoke directly to the bench, and his head was to everybody, the back of his head was to everybody else in the room?
I think it was odd. And I mean, I hate the layout of that courtroom. It's kind of like a hybrid federal courtroom where they will put, you know, the prosecutor table in front instead of side by side, front and back. But I'm only a little surprised because, you know, he is the new sheriff in town. He is the experienced one. He's supposed to be the charismatic one. And I think in terms of projecting, I'm in charge here, I would have thought in light of that layout, yeah, you go to the podium, let everybody see you, let the defense see you. It's probably a more professional way to do it. But at the same token, I agree with what you said. I don't think it's the biggest deal in the world. I mean, he just stood up and talked. I don't think he was trying to be disrespectful. I don't think he was trying to be arrogant. I just think he stood up and talked where he was standing. And it just turns out that courtroom, you know, has a pretty terrible setup. That's all.
Yeah. I think, unfortunately, I think a bunch of older courtrooms in Massachusetts are like that. When I first got out of law school, I did try some criminal stuff over in the East Boston District Court. And that was one of the first things that struck me, was that the prosecutor has a little table that's almost attached to the bench. And then we poor defense attorneys are sitting behind that. And I've noticed that in a bunch of smaller courts in Massachusetts. Maybe it's not that way anymore, but some of the older courts are like that. Now, the next question I have for you is, Karen Read, as we all know, has talked. She had the article in Vanity Fair after talking to the reporter in her house for 3 days. There was an article in Boston Magazine that was 18 pages. She's been on ABC. She's been on NBC. And as you know, the Commonwealth, per Hank Brennan, is now subpoenaing NBC 10 Boston, WCVB, ABC Boston, and the other magazines I mentioned. Now, what significance do you make of that? As a defense attorney, would you allow your client to make all of those statements? And the second part of my question is, what if she takes the fifth at the trial and doesn't testify? Doesn't that look kind of bad that she made all those statements, but she won't talk to the jury?
So, you know, it's an open case. She gave these interviews while it was an open case. It seems clear that the understanding was it would air after the trial. Of course, who's going to predict that means like after trial 1 and there's going to be trial 2. Would I personally, with an open case, have had her speak? No. No. The answer is no, absolutely not. Having said that, I don't think, well, let me back up. Right now, the prosecution appears to be in like fire drill mode. They're filing all these motions all over the place. They're asking for more time. We need this. I'm bait stamping. I'm doing this. I'm trying to do this. And, you know, again, go back to what happened. I haven't had a chance to watch the whole trial, but I'm going down every rabbit hole about what Karen Read may or may not have said regarding, you know, what happened. And based on, you know, what has been put in the motions and what she said, to me, I don't put a lot of weight in this. I mean, I think they're really splitting hairs about it. If they're really going to call some of these witnesses, I think they're making a mistake. It's shocking to me that with a straight face that they would call her parents. You know, if you've watched this case or you know anything about it, they're as sympathetic as it gets. I know them personally for what it's worth. They're very nice people. I'm in full disclosure. I've met them. They're really nice, and they will humanize Karen Read, who, you know, some people believe may not be the most sympathetic figure sitting there. You've heard a lot about that. So if
I think she's very sympathetic. I think she's an attractive, she carries herself well. She dresses professionally. I think when you do hear her speak, I'm very impressed. And
yeah, no, I don't, it doesn't offend me either, but a lot of people, oh, she comes off, and maybe that's just sexist and, successful, attractive woman, who knows? But the point is, if she's not going to testify, you're almost doing the defense a favor. If you have her parents testify, it will humanize her. At what cost? That she called her parents in a time of crisis? I don't think that's a big deal. I think that's normal. Okay. They have a very close relationship. A lot of crazy stuff is going on. Daughter can't find boyfriend, so calls parents. Is that so crazy? It's not. It doesn't strike me as wow.
Yeah.
If they're going to fight over, well, she said she went in the front door and it was actually that second front door, that strikes me as nothing. When she made hypothetical statements saying, in my mind, I was running it back, could I have hit him? In their motion where they italicized the big part of the statement, they didn't put italics on the word could.
Right.
Which is kind of burying the lead. That's kind of the point. It's not a confession. It's a legal admission if you offer it against her, but she wasn't saying I hit him. And this is similar to what, you heard at the trial too, with some of these witnesses saying, did I hit him versus I hit him?
Right. But that's significant. Did you used to be a reporter or work in the media? Because that's a saying that I used to work in the media. That's something that reporters always say, don't bury the lead. Did you used to work in the media?
No, but I have a lot of friends who are, from my lawyer days, who are reporters at every media outlet you can think of on the East Coast and national, and just deal with this all the time. And it's an expression I like and use a lot. And when you see these kind of stories, unfortunately, the lead gets buried all the time. Yeah. Like the same thing going back to the whole Brennan got hired. The lead was not Whitey Bulger. The lead is, what the hell are you doing when you have an office full of attorneys? I mean, they just lost
exactly. It. Now, I know we promised to get you out of here at a certain time, and I know we're running up against that time. So I'm not going to go over all the documents. I personally, even though I'm an attorney and have been for over 30 years, I personally think it's boring just reading the documents. But I just want to take a look at one of three before you go. Get your impressions. This is the Commonwealth's motion for a protective order. Trooper Proctor text messages. The Commonwealth moves pursuant to Mass Rule 14 that certain materials being provided as discovery in this case, which may be evidence in an unrelated pending criminal case, be redacted for personal identifying information of minors and unrelated individuals. A pretty standard kind of a thing. As grounds under the same rule, the Commonwealth provided notification regarding the testimony by Trooper Proctor in the Reed case, which ended in a mistrial. And it goes on. Look at that. Allowed. No opposition. B. Canoni. So the motion was filed on November 13th, the day of that hearing. And she allowed it. This is one of three motions for a protective order that she allowed with no opposition. I think that's kind of strange, don't you?
It is, although in all fairness, I don't know whether the defense was notified and said, just give us the material and we'll revisit this later, depending on what we get. But yes, it's not common, especially in a case this contentious, over materials which could be quite salacious, and quite helpful to them, given that their whole theory is that Karen Reed was framed in large part by Michael Proctor, amongst others. But what she appears to have written here is that on the same day the motion was filed, I'm granting it, and the defense didn't want to be heard. I don't know if they really did that. I don't know. You'd have to ask them. I have no idea.
Well, I will. As you know, I don't mind calling people that I don't know and asking them questions, like I did to D.A. Morrissey's office and asked a question. And even though he has a full-time taxpayer-paid press guy, they didn't respond. But I don't know. I listened to the whole hearing, as I know you did. I watched the entire hearing live, and then I went back over to pull out some video clips that we showed in a different episode. But I didn't hear this brought up at all, at least in open court. So I don't know. I just thought that was
I didn't hear any reference to that either.
So I know we promised to get you out of here at a certain time, and we're pretty much up against that time. I always ask Lainey, but it's your turn. Do you have any closing thoughts for us today?
No, happy to talk about it. Nice to meet you guys. And, it's a fascinating case, and I think it's important that the public be aware of it, because there were some very concerning issues. And it's good when the public is engaged about what their tax dollars are doing and who they're prosecuting and why, and based on what evidence. So maybe some of the Twitter rhetoric should calm down from people with respect to the case, but it's good that the public's engaged. That is good.
Are you originally from Massachusetts? I heard you're from Framingham.
I am. Yeah.
Okay. I just wondered.
Yep.
Okay. What got you down to New York?
I wanted to be a prosecutor. So Manhattan is the place to be. So once that opportunity became available, I ended up in a place that, I mean, look, I'm from Massachusetts. You know how it is when you're brought up there. New York is hell on earth. You don't go.
I was going to say, yeah.
Lainey's from New York.
Yeah.
Certainly don't live there. I mean, if you had asked me even 5 years prior that you would end up working and living in Manhattan, I would have laughed beyond belief. But, you know, things happen for a reason. And so I started work there, and that's where I've been since.
I was telling Andrew previously that it's crazy for you to be working in Manhattan because it's so cutthroat in New York. I was away from the city. I was about an hour away from the city, and I was so spoiled going into places and saying, "Are you hiring?" And then they're like, "Yeah, you got the job." And in New York, I tried applying for work in the city, and there I call. It's like, "Oh, did you get my application? Oh, you might hear back from us in 2 weeks." I'm like, "Oh my gosh, I have to compete with people." Like, New York is very competitive.
If you want to be a trial lawyer, there's no better place than in Manhattan, because they'll throw you right in, feet to the fire, and your elbows will get razor sharp very quickly. And I mean, it's a good place to cut your teeth, to just get into the arena, as they say. So,
my grandfather was an attorney in New York. He had an office on 6th Avenue. He was a tax attorney, and unfortunately, he passed while I was in middle school. So unfortunately, I have fond memories of going to New York as a little kid. Here's my closing thought. Everybody makes such a big deal about Hank Brennan, the Whitey Bulger attorney, and I like Hank. I've met him. He's a sharp guy. I have nothing at all negative to say about the guy. But so what? He was Whitey's attorney. Remember who won and who lost in that case?
Yeah. I mean, well, that case is interesting. First of all, no lawyer should ever be judged by the client they represent. So I don't, the people who attack him for representing a psychopathic mafia boss, mass murderer, that doesn't make the lawyer a bad guy.
No, of course not. That's not what I meant. I'm just saying.
No, I know you don't mean that, clearly. But some of the people who's, oh my God, he's a mob lawyer. No. The other thing is, well, the Whitey trial, that's a show trial. I mean, let's be honest, okay? Yeah. A federal trial against him was only going to end one way.
Exactly. I agree.
So there was really no pressure whatsoever in that case, as opposed to this case. There's a ton of pressure and reputation.
And Hank's point in the Whitey Bulger case was not so much, as you just pointed out, we all knew what the result was going to be. His point was not necessarily to get a not guilty, although I'm sure he would have been ecstatic. His point was to unveil the absolute, outright, total, deep corruption in the FBI office and federal government in general in that case. It was as corrupt as it gets. And anybody that doesn't agree with me needs to read a couple of books or watch a movie or a Netflix, and he did a good job. He did an excellent job unveiling all the corruption that went on in the Boston FBI office back in the 70s, 80s, early 90s, I guess.
Well, but that's also the irony, because now, the screw is on the other foot, because if you can't, not you personally, if you can't see the likelihood of some degree of corruption in this case, it's everywhere.
It is. Absolutely.
It is. I mean, you can argue over whether Karen Reed is guilty or not guilty and all of that, but to call this a clean case and good police work that's a joke. It's not.
I think you made I don't mean to cut you off. I was going to just say, I think you made an excellent point when you pointed out how this is like one of their kin. There's a man down and they're not closing off the scene. We're using solo cups and Stop and Shop bags, where in any other situation, like you guys were saying in the city, dozens of cop cars.
It's absolutely insane. And to me, I don't even know if they made a big enough deal about this, frankly, at the first trial, that you would just have so many boots on the ground so quickly. You would have off-duty cops volunteering on their own time to do this. I mean, there would be so much paperwork generated in the first 48 hours.
Oh, absolutely.
Investigate every avenue there was. I mean, they weren't even talking to people inside that house for months and months. It's truly, I mean, if you come from a law enforcement background or criminal justice background, prosecutor, defense attorney, police officer, that kind of thing, and you look at the way this case was handled, it's ridiculous. If you go outside the bubble of the people who support the Massachusetts State Police or are friends of, the Albert family, that kind of thing, go talk to any law enforcement officer who give them, I'd say maybe 30, 40 miles out of, the Canton bubble and say, what do you think of this case? And to a man and woman, every single police officer will tell you this thing is rotten to the core and stinks to high hell. Every single one.
Agree. Thank you so much for your time. Like I said, we agreed to get you out here at a certain time, and I really thank you for your time. Look forward to hearing you elsewhere, but also hopefully here. So have a great weekend.
All right. Thanks, guys. Take care.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.